Good evening, ladies and gentlemen. You're welcome to yet another in our series of webinars aimed at our clients for the purposes of helping you do your jobs better. Contentious planning, Greenbelt, Brownfield, Section 106 agreements, objections and appeals that occur in the course of the planning is what we are talking about this evening. Now, as part of housekeeping, before kicking off, it is appropriate for me just to let you know that I'm having to speak to you today from one of the Spanish islands. As a result, I hope that should we have any technical hitches in the process, I crave your indulgence to please bear with me. My technical team tells me that they're able to deal with whatever that comes up, but we don't anticipate that much will come up. So as we kick off, now, for those of you who are new to our webinars, I'm Samuel Okoronkwo. I started my professional life as a quantity surveyor. I was a construction project manager for several years and participated significantly in development as a property developer before, of course, becoming a barrister. So what I speak to you about this evening are born out largely of practical experience, academic knowledge, and of course, share intellectual development. So I hope it's of benefit to you, and then you can deploy what you hear from me in the course of doing your jobs. So as a barrister presently, I tend to spend much of my time addressing contentious planning issues for clients, challenging excessive Section 106 and community infrastructure and levy demands from local authorities, addressing and reversing where appropriate planning objections, dealing with planning appeals, and reversing planning contravention notices that are served upon clients. So the starting point is to say that contentious planning is all about making adequate preparation. If you're going to become involved in contentious planning, you have to be able to anticipate the issues that will arise, address those issues, and then be in a position to make your own positive case for your scheme quite robustly. And I tend to find that when applicants take that approach, success is more likely than not. So what are the common reasons that we encounter day in, day out in contentious planning applications? So the reasons why planning applications become contentious could be political, it could be part of overdevelopment, environmental issues could give rise to it, transport is a significant part, there is always a community impact of any major development, policy issues come in, existing development mix is often also an issue of contention, infrastructure, public services, public opinion, economic value, sustainability, amenities, heritage. These are all issues that can make your otherwise innocuous planning application to become contentious. You should think along these lines and ensure that these matters are all factored in and considered before making your planning application. I tend to advise clients that commercially viable consent should largely be won before you submit the planning application form. That is to say that you cannot underestimate the necessity of thinking about the reactions to your application before you actually do it. So the issues that I referred to in the previous slides are things that ought to be considered, should all have been considered, and the relevant boxes ticked off before you submit your planning application. And then you'll be certain that the reactions that follow will not be, if you like, will not come to you as a shock. So if we look at brownfield development sites, you will find as a matter of course that they are not as contentious as greenfield developments. There are issues of public perception to be considered. The promoter, the developer who is advancing the scheme, ought to properly consider the costs of cleaning up the existing sites that you're looking to redevelop. Check for, identify any contamination issues and have it addressed, and then see how that impacts upon the profitability of your scheme generally. And if you have take those off and the scheme is still viable and profitable, then by all means it's worthy for you to proceed with. Of course, there would always be consideration of community infrastructure levy, because when you're redeveloping an otherwise derelict environment, you will be bringing additional traffic if you have a successful development. And it isn't unusual for the local authorities to look upon you to make a significant contribution to deal with the additional traffic and volume that you'll be bringing on. With respect to Greenbelt, as you will be aware, the entire concept of Greenbelt is actually designed to restrict development within the Greenbelt zone. It's highly contentious, but as you will also appreciate, there are currently pressures on the local authority to generate new homes. The government pressure on local authorities to produce land for development tells on the local authority. There is often a consideration as to whether there is brownfield availability for the same development, or whether the local authority is actually meeting their development land quota. So when you're trying to convert Greenbelt land into development land, there are significant challenges to be considered in that respect. The local authority may be reluctant to approve your application due to political pressure. There is an obligation often on them to approve it if there is no alternative brownfield site to develop, depending, of course, on the significance of the development proposal that you're bringing forward. Now, if the local authority are not compliant in producing development land quota, meeting their development land quota, you may well find that the Secretary of State may be able to intervene, override the local authority, and approve the scheme. But of course, that is, of course, contentious. And if you're able to, you rather persuade the local authority to approve your scheme. You also need to consider whether your development is going to cause an entire rezoning of a local area, or whether you're looking to change the use of a particular building site. Very important to have all those. So more often than not, I tend to use live examples to illustrate what we are dealing with. So this is actually a live instruction, although we received it a while back. It is still ongoing, and it's always worthy of going through it. So this is a client writing to my chambers director with respect to the difficulty that they have. He says, "Many thanks for your prompt reply in this matter. Now it's important to actually go through this so that you can see the impact. Please find as requested breach of planning letter from the local authority which they have received." Now, email confirming from their solicitor that they did not require, there was no restriction on the property being developed for the purposes for which they are required, which amounted to a change of use. There was also an email from the seller's agent confirming the current usage of the site. They provided their title deeds, always a prerequisite. And significantly, a survey report where in the valuation report from the bank's valuer identified what the current use of the site is, of the property, and then suggested what they might do to ensure that their intended use was, if you like, compatible. But then bear in mind in this case that they have a legal advice that they didn't need to do anything, that they can proceed. So the council in this case requested for them to send an acknowledgement that they will stop all the development that was in progress forthwith. They were required to, in fact, remove all of the new structures that did not have planning consent. We're talking about a greenfield development here, and at this point, they had already concreted over the site, 95%, and this was a very significant piece of land. And any of you that have dealt with Greenbelt development will know that they absolutely detest concreting the site. So they now are required to stop their activities, and they require our attention, and they're unable to deliver what is being required of them. And then they've made this matter to be urgent and required our immediate attention. So on receiving this, now this client has come to us following the receipt of a planning contravention notice. The requirement was to remove all structures and to reinstate the site to the position that it was within a period of 28 days. They had been advised by their solicitors that the change of use was not necessary. they needed to repurpose the site from a sui generis use class to what I describe as a B8 storage and distribution. They're a construction services and development company. Now, as I said, they concreted over the site. They had their fleet operation license changed to that address. The local authority has issued a notice of prohibition, and they served it not just on the company, but also on their mortgagee, the bank. And of course, the bank promptly gave notice that they will recall the loan, which to all intents and purposes was going to lead to the collapse of the business. Now, the approach we adopted was, first of all, although I've written this top side down, first of all, we engaged with the bank and persuaded the bank that it would be in their better interest to at least allow time for us to engage with the local authority to see if this situation was salvageable. The bank obliged. We reverted to the local authority and sought their accommodation with respect to enforcement. Luckily, they obliged. Then we engaged with them. We analyzed the scheme, saw what we considered to be contentious elements of what has been built and what was, if you like, less contentious. We adopted a methodology of reverting to them to seek retrospective planning consent for the non-contentious part of the development in the first instance. Luckily, we scored a success in each and every of those sections because we actually literally broke the development down. Clearly, when you make a retrospective planning application for a non-contentious element of the development, it's rather difficult for the local authority to refuse. Because of course, if they refuse that, one can appeal it and appeal it successfully. So we persuaded them in the first instance to approve all of the non-contentious elements of the development, which enabled us to gain trust and then for them to believe that there is actually a path to redemption. Now, that is what I tend to sometimes describe as a death by 1,000 cuts. In other words, making incremental planning applications in order to bring the local authority with you. Because when they're used to saying yes, 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 often saying no becomes not impossible, but a bit more difficult. So we have actually moved this on now, where we're beginning now to gain consent for what you might otherwise describe as the more contentious elements of the development. And this matter has actually exploded because whilst we were in the middle of this matter, we found that the rating of the property had changed. The valuation office decided to, I believe in this case, raise their rating or rateable value by 300%. And of course, that was commensurate to the rate bill that they received. And that's an entirely separate matter that we're presently dealing with. Now, having said that, I find this video that I'm about to play for you now quite instructive, and it would be most helpful if you can listen to it for a couple of minutes and then we can continue.
He's going to say something new and radical in the broadcast.
What, that silly grand design? Bernard, that was precisely what you had to avoid. How did this come about? I shall need a very good explanation.
Well, he's very keen on it.
What's that got to do with it? Things don't happen just because prime ministers are very keen on them. Neville Chamberlain was very keen on peace.
He thinks it's a vote winner.
Ah, that's more serious. Sit down. What makes him think that?
Well, the party have had an opinion poll done. It seems all the voters are in favour of bringing back national service.
We'll have another opinion poll done showing the voters are against bringing back national service.
We can't be for it and
Oh,
against.
of course they can, Bernard. Have you ever been surveyed?
Yes, well, not me, actually, my house. Oh, I see what you mean.
Well, Bernard, you know what happens. A nice young lady comes up to you. Obviously, you want to create a good impression. You don't want to look a fool, do you?
No.
No, so she starts asking you some questions. Mr. Woolley, are you worried about the number of young people without jobs?
Yes.
Are you worried about the rise in crime among teenagers?
Yes.
Do you think there's a lack of discipline in our comprehensive schools?
Yes.
Do you think young people welcome some authority and leadership in their lives?
Yes.
Do you think they respond to a challenge?
Yes.
Would you be in favour of reintroducing national service?
Yes. Oh, well, I suppose I might.
Yes or no?
Yes.
Of course you would, Bernard. After all you've told you can't say no to that. So, they don't mention the first 5 questions, they publish the last one.
Is that really what they do?
Well, not the reputable ones, no, but there aren't many of those. So, alternatively, the young lady can get the opposite result.
How?
Mr. Woolley, are you worried about the danger of war?
Yes.
Are you worried about the growth of armaments?
Yes.
Do you think there's a danger in giving young people guns and teaching them how to kill?
Yes.
Do you think it's wrong to force people to take up arms against their will?
Yes.
Would you oppose the reintroduction of national service?
Yes.
There you are, you see, Bernard. The perfect balanced sample. So, we just commissioned our own survey for the Ministry of Defence. See to it, Bernard.
Right.
So he's going to say something.
Now, interesting, that last video is valuable and instructive because it just gives you a demonstration of how one is able to achieve, if you like, alternate results using the same set of facts. Is a matter of approach and interpretation. But anyway, one makes swift progress from that. And now I move on to Section 106 agreement. Now, Section 106 of the Town and Country Planning Act 1980, as amended, covers the opportunity for the local authority to derive a planning gain from the development that is proposed. Now, it's a legal agreement which binds the local authority, the developer, and any other parties with interest. Largely, the parties with interest are, of course, the banks and the mortgages that finance the development. Now, the objective is to regulate the development and make it acceptable. Acceptable is in quotation marks, there for a reason. Now, the legal test is that it is necessary to make the development acceptable. It must be directly related to the development. It must be fair and reasonable in scale and kind to the development. Now, it can be a financial or non-financial payment. It's calculated by the local authority to give maximum and minimum values usually. But most participants are unfamiliar with how the local authority calculates the value of this Section 106 demand. And it is my significant urging that you ought to be. Now, I hesitate to pause here to say that I have been asked to do a more detailed and in-depth, if you like, session on various aspects of contentious planning. So I know that we're time limited to an hour this evening, so I'm racing through these things. And I believe we have a date that is set down in July, where we're going to sit down in a workshop, spending half a day working through the constituent parts of this contentious planning elements of the things that I'm touching upon this evening. And Section 106 is, of course, a critical part of it. It's a non-standard calculation, so it's variable in developments, following each development with its own particular characteristics. So what is important for you to appreciate here is that in Section 106, you do not necessarily get what you deserve or what you're entitled to, but you get what you can negotiate. And negotiating, of course, from a position, an informed position, is negotiating from a position of power, wherein, as you will see in a later example, where the local authority make a demand that is not entirely reasonable, you will have a basis for rowing back from it. It's significant to know that it must directly benefit and be relevant to the area in which the development is situated. And there's been cases where it is said that particular developments are taxed, and then the proceeds that the local authority gets in a Section 106 is then spent in a different part of the borough. That ought not really to be the case, and the developers ought to have a say in being able to direct that. So one example in this regard that I gave is that a client came to us after accepting a Section 106 agreement that proposed that if the development was to be sold at greater than £450 per square foot, the local authority will be entitled to a 20% of the uplift. Now, this is what is usually called an overage. in a Section 106 agreement if you're used to either negotiating or drafting these. Now, by the time this development was actually completing, it was being sold for £650 per square feet. And you can imagine the local authority stood to gain and collect an extra £2 million. And they were keen on getting that. Now, the client came to us, of course, although he had an agreement in his hand which obliged him to pay extra £2 million. He was, of course, reluctant to do so, and for good reason. And he sought our advice. We felt able, in the circumstances, to engage with the local authority to challenge the enforceability of the Section 106 agreement in the form at which it stood at that time. Now, in many of these cases, you would note that the expediency of securing planning consent often leads to developers, if you like, not challenging most demands that they get at Section 106 pre-planning time. So they settle with the agreement as has been presented to them. They sign it, they gain consent, they begin development. And when they, of course, come to paying it, then they may struggle. Now, in this case, the agreement contained clauses covering variables in the local authority's income. By my interpretation, it favored the local authority. It did not provide commensurate clauses to cover variables that might impact the developer. Now, when we picked up this agreement, we felt the necessity to interpret the overage clause differently. We offered an alternative interpretation of these variation clauses, which to our mind struck a fairer balance between the interest of the local authority and the interest of the developer. Now, prior to coming to us, the developer had been advised that he had no out in this agreement. He simply had to hand over the $2 million, which would have, of course, hit their profit significantly. When we drove home our reinterpretation, it was rather satisfying that the local authority eventually settled for an uplift of £180,000 as compared to the $2 million, which the agreement prima facie had presented that they were entitled to. So I look at, just going rapidly and being conscious of time, the objections and the appeal system in the planning. Now, managing and discounting planning objections proactively is a very good approach to adopt when you're looking to secure contentious planning. You want to be reviewing the refusals in the light of the previous decisions that the same local authority or neighboring authorities may have made. You then have to consider whether you appeal or resubmit. More often than not, I'm being approached with clear instructions to appeal this refusal. And on reflection, on, if you like, more than average, I tend to advise that a resubmission with the various objections addressed may produce a quicker, more cost-effective, and indeed a better result. Because if you consider the typical appeals process may take of the order of 24 weeks. So we do that quite regularly, and we find that sometimes, not always, resubmitting might actually give you a better result than appealing. Of course, sometimes you just have to proceed and appeal the matter straight up to get to the end. So as I indicated earlier, it is on the 12th of May. We kick off at about 2 p.m. till about 5 p.m., where we concentrate and go through in greater detail the matters that I have only just but done a whistle-stop tour of this evening, considering what the, if you like, the time implications, the time restrictions on us this evening is. So bear that in mind. Now, I know that these, at this stage, covers matters in general, but if you want to dig deep, get into some worked examples, have specific issues that you would like addressed, and you want to know how to deal with it, that may be a session for you. If it's a session for you, you're most welcome to join it. Now, I'm told that I often speak for too long in these webinars, so I pause at this stage, and it's Q&A time. And I hope we'll be able to still wrap up within the reasonable hour. So I speak for one half of it, and we'll leave one half for you to ask your questions. So away we go for any queries there might be.
Samuel, can I ask a question?
If you must, yes, please, go ahead.
The example you gave earlier with the concreting over Greenbelt, you mentioned about obviously local authorities are really trying to avoid Greenbelt, but they're under an obligation to provide land for development. What happens when the local, or how do you deal with the local authority where they're basically sat on the fence? They don't want the Greenbelt, but they don't have the Brownfield, and all the policies and procedures of what they should be doing, they're not doing. How do you drive that issue home when there's no Brownfield, there's Greenfield, but they're not saying Greenfield either? They're kind of ignoring their responsibilities to provide land for development.
Well, I'm sure that many local authority participants who are in this webinar will violently disagree with you that they're not doing their jobs. Now, we have to recognize they're a public authority. To a large extent, they're limited by resources and funds. So they're running as fast as they're able to. And often the sheer political or policy restrictions make it impossible for them to do. Now, one can persuade them depending on whether, in fact, we're working on one now where there are exceptional circumstances that have to be demonstrable in order to persuade the local authorities. So, for example, if you're bringing substantial economic value, which will not just assist employment, but make substantial Section 106 contribution, a local authority might otherwise be able to look at the matter from a slightly different perspective. And that is, of course, to leave aside the facility that exists for one to go straight to the Secretary of State, for the Secretary of State to override the local authority. Now, when one does it like that, you're taking contention to the highest level. I'm always of the view that a development sits within a context. You're within a locality. You're within the environment where you want to coexist. So you don't want to antagonize every possible neighbor you can, including the local authority, by literally extracting, if you like, the planning consent against their will. Far better, in my view, for you to persuade them from a position of reluctance to that of support. Even if they were grudging, ultimately, the fact that they have decided to tick the box and say, okay, we reluctantly, but we nevertheless grant this consent. That, I think, is far better. And one can usually achieve that. And we find that we can do that. It's a lot more work. But then again, you try and avoid the contention, because when you start the contentious process, it becomes far more expensive. So how do you do it? You do it by persuading them, and in the extreme, if they're just sometimes in exceptional circumstances, you meet some unreasonable people that you can never persuade, then of course you're either appealing it or you're appealing it through the inspectorate, or you're appealing it direct to the Secretary of State. For it to be called in. It depends on the scale and the significance of the development. You would have seen, I think, in the last day or two, the government published, if you like, an outline of their new energy policy. And in that, there is a debate between offshore and onshore wind. And with respect to onshore wind, there is a whiz or was that localities that prefer to have it and get the saving that comes from their low energy bill can have it. And those who don't want it, but will prefer to continue paying high energy bills, may not be allowed to have it. So this is where both policy and politics meet. And you find that our Town and Country Planning Act actually is local democracy at work. And that can, if well understood, it can be played effectively to achieve consent. Did that answer your question?
Yeah, and I'll follow on if, sorry, if nobody wants to chip in, I'll throw in another one. You've mentioned politics quite a bit here, and you mentioned the, what was it, consent by 1,000 cuts. Can you tell us a little bit more about the consent by 1,000 cuts and how that plays with politics?
I think actually I see consent by 1,000 cuts more a professional approach that I think trumps the political approach, because the development as a whole will not get planning consent, or in cases where we tend to adopt the methodology, more often than not, there's been contravention, or sometimes there is an outright refusal. So you find what is non-contentious, you apply for and you gain consent for it. Because once you've established that positive relationship with the local authority, you've persuaded them to grant consent on a particular site for something. When you return a second time, you're not just new, because more often than not, the planners see the developers from a different perspective. You're an exploiter. You want to do something that for some reason policy does not allow you to do. But when you've demonstrated that you're sufficiently sympathetic for those requirements, and you have driven a particular application home, when you return a second time, the view that they have of you is slightly different. It's more welcoming. I find that I get called Samuel rather than Mr. Okoronkwo. In other words, you've broken the ice, and then one can then make progress. So if you identify that and you're able to properly analyze your application, so you can slice and dice it. In fact, it's no different to what one does in construction project management, where you have work package breakdown. So you break things down into specific, as much as you can, self-contained packages. So you pursue one package from start to finish, and then you bring the other package, because the local authorities, they will see each planning application in isolation. So if you're able to persuade them in isolation that is worthy of consent, and that consent is granted, you may well find that if you've broken it down to half a dozen jigsaw puzzles and you've secured 4, when you come for the last 2, the thing speaks for itself. It makes practical sense for consent to be given. And then also you notice that objections are reduced in those circumstances. So that is what I tend to, in a manner of speaking, call consent by 1,000 cuts, because you're making incremental applications and you're being successful. Hope that helps.
Samuel, can I ask you about design issues, which are a bit subjective? I had a planning application which was very contentious with the locals, and the planning authority were seeking to refuse it at committee, which was evident at the committee meeting. We got an officer recommendation for approval.
Positive.
Yeah, well, we thought so. The chairman of the committee asked the chief planning officer if they could refuse it on grounds of transport, and he said no, we'd met all of those criteria. It was a retail scheme, a small retail scheme, a little convenience store. So they asked if they could refuse it on the grounds of need and demand and those sorts of issues, and the chief planner said no, but he said you could refuse it on design if you like. So they refused it, and we thought, well, that's not a real problem, we'll have to go to appeal. We'd agreed the design, of course, with the officers. Unfortunately, when we went to appeal, the inspector decided he didn't like the design either, and he rejected the appeal. I did actually write to the then Minister for Planning and said, this is just a nonsense. The officers have approved this. This is costing a fortune, wasting time on a design that was approved by professionals. Of course, he didn't get involved at that point. But what would your views be on that sort of situation, given that design is so subjective?
I'm actually, I'm sorry to have to say this, quite offended, because actually town and country planners are not allowed to reject a planning application on design, because the design has always been accepted as being the domain of the architect. That is why our streetscape is unique. Now, if you have, Victorian Georgian streetscape, and you're going to introduce a Tudor, they can say that if you like, the overall amenity and the streetscape might be adversely impacted. Now, that is to the extent that the planners are allowed to go into intruding into the architect's realm of operation. They shouldn't say they hate your design. They may suggest improvements which will make it more palatable, to make it fit better within the environment, but to actually pick out. Now, I think that is a very, very ripe case for appealing up to the High Court, because the deliberations at committee stage, you're telling me, is that they asked, can we reject it on this basis? The answer was no. Can we reject it on that basis? The answer was no. So there appears to have been a closed mind, a predetermined position that we need to reject. We're just clutching our straws to find a reason to reject upon. That in itself, a record of that meeting, will actually interest a High Court judge looking at it and say, well, hang on, is this rejection for the sake of rejection, or rejection for a substantive, sustainable Town and Country Planning Act reason? From what you have just described to me, it doesn't seem to me as though it fits that criteria. And let's face it, town planners don't teach architects how to design. So they shouldn't be telling you how you design your building. And particularly, you say that the design appears to have been pre-agreed with them, hence the recommendation. And thereafter, the same planning officer offers an advice that they could reject on the grounds of design. The matter perhaps warrants revisiting, because I would have thought that that is reversible on the face of it without getting into greater detail. But that's a matter that we can look at in greater detail if the promoter is still desirous of advancing it.
Thank you.
Samuel, there are two other questions here.
Please.
One is it realistic to consider appealing or resubmitting if the driving force behind the refusal is political, or rather the local MP, who is actually following opinion poll, only speaking for the few in the area and not those thinking of the jobs and associated benefits?
Well, yes, often. Now, I think it is when one gets behind a reason behind a refusal that the decision can probably be made as to whether a resubmission will be more appropriate than an appeal. If one comes to the conclusion that the politics of it is such that whatever you do, they are going to refuse, then one wants to analyze in detail the reasons offered for the refusal and then appeal. So I'm not saying that a resubmission always solves the problem, because when there is a refusal, one wants to get to the reason behind the reason, if that makes sense. And when we establish the reason behind the reason, that is when we make that decision. But if it is politics, just for the sake of it, and it's politics and nothing else, then one wants to look at it, say, well, I was asked to advise recently on the development of what is to become a commercial nursing home in a highly residential area. And the overall approach was that it was going to significantly change the character of the area as a result. And it wasn't considered that the need existed, given what was available in the locality. I gave a different type of advice in that case, and it wouldn't be appropriate for me to get into greater detail on that. So one often looks at it and seeing where is the politics and can that be reversed? And often good PR on the ground actually can turn the tide in the politics. And you get those who are the arch objectors becoming the lukewarm supporters. And you find that because they are not leading the pack, the gross number of objecting signatures that you will receive will substantially diminish.
Interesting, because now there's following on this political sort of thought. We have another question which asks, from a local government point of view, the unwillingness of some developers to engage with the community, particularly on those issues which you highlighted, for example, transport. Why is this the case, do you think?
Sorry, do me a favor. Can you just repeat that? I'm not sure that I got everything that you said.
Okay, from a local government point of view, the unwillingness of some developers to engage with the community, particularly on those issues which you highlighted, for example, transport. Why is this the case?
Well, the developers come with a degree of unwillingness to engage because, as we've just heard from the prior question, you find that the scheme that you've articulated that meets with your design requirements, you get the local authority planner trying to dictate to you what you should design, when that is not really their role. That is on the one hand. And the other is that engagement with them, they probably take the view that the developer is loaded with cash and therefore can do a lot more for the local authority than is actually realistic. But then again, I think that is a matter of better communication between the two, because ultimately, most developers that I encounter have their schemes funded by way of debt and minimal equity, and as such don't have too much elbow room, because whatever they spend on the local authority is part of their development costs, for which they will pay interest, and then they will need to recover in the profits of the scheme. So I encourage developers that I advise to engage with the local authority. I find that is often, well, more 9 out of 10 cases gives you better results than not engaging with them. But then I can also see that some local authorities make it far more difficult than is necessary for the developers to engage meaningfully with them by discouraging them with, if you like, an excessive demonstration of authority on the one hand, and then of course making demands which may be financially unsustainable for the development. And those are my, if you like, initial answers as to why that might be the case.
There's no more questions at the moment.
We have one, Samuel. This is from Kathy Hines. She wants to know, how was the Greenfield development subject to an enforcement notice when all had been checked beforehand?
Now, that's a very interesting question. My clients had received advice from their solicitors that they didn't need planning consent. Indeed, the bank had lent them the money. They'd begun development, but immediately I saw it, it took me literally 5 seconds to conclude that there was no way you could be proceeding with this development without consent. So it's a straightforward fact that they received defective legal advice at the outset. And they were caught on the hop, as was the bank. But then, as always, the bank can always recall their loan, and then the developer is left holding the baby. But I'm rather pleased to say that in the present circumstances, we have thus far been able to salvage it for everyone's benefit. So they received advice that was defective, and that was what caused it. Suffice it to say that the people who gave that advice may be subject to a professional negligence attack, but that is not within my remit, and I should leave that out of this webinar.
There is one more question from Jay Johnson. Oh, in fact, two. Another one's just from Johnson. How would you recommend?
Johnson, is that Boris? Hopefully not. Okay.
How would you recommend we deal with planners and other consultees changing their minds through the planning process? And also, how can we push back on design comments from a planning officer? I think these are two very pertinent ones.
Yes, they are. With respect to dealing with the changing minds in the course of the planning process, I always recommend adequate documentations of what I consider to be settled matters, settled issues. Okay, now there are things you will take to the planners beginning from a pre-planning stage, and certain requirements that you have the boxes as ticked. Now, if that begins to change, you should also record that is beginning to differ from that which you have been led to believe and accept. And that would help you no end in the course of trying to reverse any subsequent refusal, particularly if you've ticked the boxes, as I was answering in the previous question, where everything is agreed and then it is suddenly rejected at the end. Now, what one has to understand, because what one has to understand is that this is a matter of local democracy. Therefore, the committee could override the officer who has recommended it positively only if there are material grounds for doing so. It doesn't follow that whatever the officer has written will go through, but trying to identify the difference between the basis upon which it was recommended for approval and the ultimate basis upon which it was refused. That is the lane, that is the avenue that one has to reverse that refusal, either by way of resubmission, if the avenue allows that, or by appeal. And you will find a greater success where there is a positive recommendation and a rather baseless refusal. One can then, if you like, more often than not, be able to reverse the rejection in the course of an appeals process. That is one. So is recording it and reminding them and putting it in writing as to what expense that one's going through. And in other words, being told one thing one day and then being told something entirely different the day after as to the reasons why your application is either to be accepted or rejected. That is one. Now, with respect to design, to planners becoming involved in design, I tend to, at a very early stage, remind the planning officer, you are not the architect. It is not within your remit to determine the design of the scheme. You have the authority to ensure that it fits within its neighborhood. That one has to appreciate that that is, if you like, the concept, and then the detail. Don't become involved in my detail. If you appeal that, I think you're almost more likely to succeed than not, because the planner should not be designing your scheme. And ideally, self-respecting architect should push back and say, no, you may not like what I'm doing, but with almost respect, I'm not building it for you. First of all, you're building it for your client and you're building it for the locality. That is not to say that one should not accept constructive criticism of a design. Yes, because you come up with a picture in your mind, and if a third party sees it and observes it, then you may well find it beneficial to incorporate some, not necessarily all of the recommendations that they may make, but to seed the concept of design from the architect, who is the master in design, to a town planner. I think that is wrong on its face, and I believe that most planning friends that I have would acknowledge I'm not the architect. I just want to make sure that it fits. So architects should feel free to push back and then put it in writing to them. So you're trying to design the scheme. You're not the architect. You can't. You shouldn't. That is ultra vires. You're exceeding your authority. Concentrate on making it fit. And I find more often than not, when you demonstrate to people on the other side that you really know what you're doing, and you can stand your ground, they tend to respect it. But then, of course, you try and avoid conflict if you can. And that's coming from a barrister.
Well, we have another question, this time from Robert Morrissey. In fact, we have 3 questions, but from different people. First, okay. From Robert, He says, what would you advise regarding the use of intermediaries, such as public affairs consultancy, to help understand local issues before making an application?
If I understand that correctly, the question is, what does one advise with using consultants to understand the local issues before making a planning application?
Yeah.
That is it in a nutshell, correct?
Yeah. Yeah.
Yeah, I advise that significantly. That is ever so important, because this is where you have a clash between policy and politics. Because when you invest in understanding the local opinion, you can pander to that opinion. So we once advised on a development in North London where the complaint was with respect to the loss of community amenities and parks and playing areas. And what the developer decided to do thereafter was to put parks and community provisions as a starting point in the development to then, if you like, encircle it with commercial outlets. So what was originally sold to the locality was the provision of new parks, new playing fields, new public community amenities. And all of a sudden, they bought into it before the main commercial element of the scheme started coming in. And in fact, they opened a local office on the high street where you can come in and chat about it. When you came in, they had free drinks, tea, coffee, beers, soft drinks. You can, sit there and gripe at them as to what you like, and they'll ask you questions. And say, we're contemplating a scheme, but we want to make sure that the, if you like, local views and opinions are taken in, because it is your development. You're going to live with it after all. It was a hit. So that is to be, if you like, recommended. That was answer one to question number one. What was the second question?
The second question is, how should local communities be protected by local planning authorities from poor design or architecture if planners are not able to push back on such poor design?
Well, see, this is interesting. It is seen to be a matter of protection, and that is where the power comes for the planners. But they are not architects. In fact, a developer who develops an ugly building will find it difficult to sell or let. Okay, and that's a matter of fact. And an architect that is producing ugly designs will very quickly run out of clients. And that is where the protection comes from. The architect professionally, has his own practice to obviously protect by producing good designs. And most developers are interested in the quality of what they're building. So planners, the way they protect their locality is to ensure that it fits within. As I said, if you have a Georgian streetscape and you're introducing a Tudor, the planner will be entitled to say, well, this is out of sync with what is usually obtainable here. But then if you're trying to keep with the same, within the same, the planner shouldn't come to you and tell you that what you've designed doesn't look as good as he would like it. Hey, be my guest, come and design the scheme then. So the local authority, the planners should be able to protect their, if you like, locality by ensuring that when it fits within it, it doesn't mean it has to be static and stale. It has to be dynamic and progressive. I mean, one of the fantastic things about London is that London is progressively being redeveloped every day. I seem to recall, in fact, before we kicked off with Canary Wharf, there used to be a restriction in central London that nothing was ever allowed to be that much taller than St. Paul's Cathedral. And because of the restrictions, when going back in those days, Michael Heseltine granted enterprise status to the Docklands and then removed all the planning restrictions. Once we designed the tower, which was that big, and all of the banks were beginning to express an interest in moving from the city to come over to Canary Wharf, overnight, the planning restrictions in central London as to height disappeared. Tall buildings can then follow. So, and this is where the dynamics actually plays out between the local authority wanting to be architects and the restrictions.
There is a question from Mike Holmes. Or it's more of a comment, and then we'll go to one from David Williams, because Mike's, it's in line with what you've been talking about in terms of design. And and what he says here is interesting comments on design. There have been numerous occasions when an architect has asked me as a planner to object to their proposals because they did not like it either, and they were only doing what the client wanted.
Okay, now that look, you see that's a fair comment. I would have thought that most architects should be able to persuade their clients as to what the look and feel of the building should be, but ultimately, he who pays the piper calls the tunes. And if the planner is objecting that it doesn't fit, and the architect is telling the client, "I told you so," then perhaps on a 2-to-1 there, because the client is being driven by a financial motive rather differently. But by that said, fundamentally, the planner should not be able to overrule the architect on the design. It doesn't mean that the planner is obliged to accept the, if you like, ugly design, because an ugly design cannot fit within a beautiful streetscape. So on that basis, the planner has a better reason for saying no, rather than saying your design is ugly, go away.
There is this question from David Williams, very interesting one. Okay. Lack of resource cuts within local authorities is often given as a reason for planning determination delay. What can the frustrated applicant do to encourage the local authority to deal with applications in a timely manner?
Well, this is a matter that has often become contentious. Now, there are circumstances where developers have offered to assist the planners by provision of resources to enable the matter to go quicker. However, there is the issue of conflict, because the local authority, the planning department, are supposed to appraise your scheme objectively on a long-arm basis. The long-arm basis then, of course, cuts across you being able to afford them assistance. Now, unfortunately, there is very little you can do other than granting the extensions that they require. But then again, I encounter this from time to time. The local authority, you can, of course, once they have exceeded the time, be able to force a decision. But the decision that you often get when you force it is a negative one. And it's, unfortunately, it's a case of trying to bear with the local authority as much as you can. But there are ways and means of, might I say, persuading them to bring your application to the fore. It is an active issue. We made an inquiry on, there's a planning matter. I think we submitted it in October last year. And it was not until, I believe, at the end of February, that we received in writing the pre-application advice, which had been discussed and agreed. But then again, I advised the client that it was in their best interest to exercise this patience, and I think that patience is being rewarded. So the frustration will be there, is nudge, nudge, chase, chase, I'm afraid. But, you know, I'm loath to try and force the issue, because if you force the issue in 8 out of 10 cases, the answer will be a rejection. Then you're back in the loop. I'm sorry, that's not the best answer, but I think that's dealing with the practicality of reality.
There's no more questions, Samuel.
There are no more questions. Okay, how are we doing for time? I think we've eaten up our hour, and it's always my pleasure to advise you all. And there is a requirement, as I said before, for us to spend a bit more time in detail in looking at these things. Hence the masterclass that we have set out in on the date that was published. I believe it is in. Forgive me, someone assist me with the date. Because of these dates in
May the 12th.
May the 12th. Thank you very much, May the 12th. So anyone who is interested in that can sign up and spend more time, and I can give more of my time in that. But other than that, I'm grateful for all of your attendance and participation, and hopefully we look forward to seeing you in our next webinar. Thank you very much.